Good afternoon. I'm happy to announce that Kuwait University College of Law, the International Law Department, are honored to host the seminar on the Hague Apostille Convention. The speakers, starting with Dr. Abdessalam Al-Anazi, the head of the Department of International Law. And the second speaker is Dr. Krestov's, who is going to deliver his insight presentation on this convention. And the third and final speaker is Dr. Bashائر Al-غانم. Please, Dr. Abdessalam.
Thank you, Dr. Bashائر. Actually, I won't talk in Arabic. After, I will transfer in English to give some ideas about this seminar. بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وصحبه أجمعين. بداية نرحب بضيوفنا الفاضل الدكتور كريستوف والفاضلة الدكتورة ميليسيا والفاضلة الدكتورة بشائر الغانم. ضيوفنا اليوم راح يتحدثون عن أهمية انضمام دولة الكويت لاتفاقية لاهاي لإلقاء الزام التصديق بالنسبة للوثائق العامة الأجنبية. وقد يبدو أن اسم الاتفاقية نوعا ما في صعوبة، لكنه راح يسهل لنا بشكل واسع تطبيق الاتفاقيات في المستقبل. والحين إذا تسمحوا لي أرحب بضيوفي باللغة الإنجليزية. Dr. Kresstof, Dr. Milicia, hi, and you are welcome in Kuwait University. We would like to thank you for acceptation to participate in this seminar.
Thank you very much, Dr. Al-Anazi and Dr. Al-Ghanim. Thank you very much for making this event possible. I am delighted to be here with my colleague Melissa Ford to introduce to you the Apostille Convention. But let me first again thank also Dr. Bashائر for having reached out to us via social media and suggesting that we do this event. I think it's a very effective means to build bridges between The Hague and Kuwait, and it's hopefully just the first step towards Kuwait's further integration into the work of the HCCH, and that this will hopefully bring additional benefits to lots of people in Kuwait and foreigners also who may have relations either of family or commercial nature with Kuwait. So without further ado, what I would like to do is, can I go into presentation mode now? Oh, thank you very much. Sorry, we had some technical glitches to sort out, but I suggest I start with a brief introduction as to what the HCCH, the organization as such, is, then an overview of the 1961 Apostille Convention, what it is all about, what this EAPP, the electronic Apostille program, has brought to the convention, and how it ensures the continuing relevance of this convention for decades to come. A quick summary then of what the benefits for Kuwait would be, and a slide also explaining the accession process as to how Kuwait would join this convention. So the organization as such, the Hague Conference on Private International Law, is an intergovernmental organization with a legislative mandate, the origins of which date back to 1893. So this makes us the oldest of all the many legal institutions based here in The Hague, and we're also the only one with a legislative mandate. We are the only organization here in The Hague that actually produces law. Our mandate is the progressive unification of the rules of private international law, as explained in Article 1 of our statute. And the way we go about this mandate is by developing international treaties, we call them conventions, to which the states can then become a party. That's one part of our work. The other important part also is the continuing monitoring of the practical operation of certainly some of our most important conventions, and trying to ensure that they remain relevant over the years. So these instruments, they deal with private international law, and what we mean by private international law is a reference to interactions between private people or commercial operators in a cross-border context. So you can easily imagine a situation between someone in Kuwait and someone, say, here in the Netherlands. That can be a family law relationship, it can be a litigation relationship, it can be a commercial, digital, or finance relationship. And in these cross-border settings, you typically have three basic private international law questions: which court has jurisdiction to hear the case, which law applies to the issue at stake, and how to go about the recognition and enforcement of foreign judgments in civil or commercial matters. These are the three traditional private international law questions, and the work of the HCCH has really added a fourth dimension, as I like to call it, to private international law, which is the cooperation between states to overcome the often very practical challenges that one may face in such an international context. So that's what the organization does. And I'm pleased to say also that the HCCH is not just the oldest and the only one with a legislative mandate. We are most likely also the organization, the work of which has the most direct practical impact on people's life, be it for family relations or again commercial relations of any sort. So this big practical impact of our work is something really important and something to keep in mind. To this date, the organization has adopted 37 conventions, 2 protocols, and 1 soft law instrument. I'm not going to present all of them in detail, but just give you an overview in a second of some of these conventions. This slide here reflects the membership of the HCCH. As we speak, we have 91 members, that's 90 states, plus the European Union as such, which in addition to its own member states is also a member of the HCCH. Based on this slide, you will understand that I never feel comfortable to say that we are a global organization. Look at Africa, but also look at the Middle East, where there is still too much gray in my humble view, and also in Southeast Asia, where we need to attract more members from. But we are, I think, doing fairly well. You see here that the growth of the membership has been really continuing over the decades, and I think that's a strong signal that the work of the HCCH is absolutely relevant, all the more so as we live in a world of private international law, in my view. Everything we do, be it as a private citizen or as a commercial operator, very quickly has a cross-border dimension, and thus raises private international law issues, and thus makes the work of the HCCH all the more important. Now, this slide reflects the fact that we have more than 60 states that, without being a member of the organization, are party to at least one convention. And you will see there also that Kuwait is colored in green, because Kuwait is not a member but party to various conventions. So based on that slide, based on the 156 connected parties, as we call them, I do feel much more comfortable to say that, yes, we are a global organization, and that the work that we're producing has this global impact. You may ask yourself, why is this thing called the HCCH when the full title is Hague Conference on Private International Law? It has to do with the fact that currently we have these two official languages, English, Hague Conference on Private International Law, and French, La Conférence de l'aide de droit international privé. And if you take the HC and CH of the name of the organization in these two official languages, you get the HCCH, which is also the URL of our website. And I should add at this stage that as of July 2024, Spanish will be an additional official language of the organization. And I can also tell you already that some Arab members have referred to the fact that maybe other languages, including Arabic, should be added as an official language, but that's something for the future. But HCCH is just a much handier way, short form, to refer to the Hague Conference on Private International Law. We have our main office here in The Hague, and we have two regional offices, one in Buenos Aires since 2005, one in Hong Kong since 2012. These regional offices have greatly helped us to increase the visibility of the work of the HCCH in these regions, and also facilitates the contacts with governments around these regions. Personally, I am on record for having said on various occasions that I think it's time for the HCCH also to have a regional office in Africa, and maybe even one for the MENA region, for the Middle East and North Africa. Again, hopefully something to be discussed in the future. So these are the three main divisions of our work: international family and child protection law. You may recognize some of these conventions listed there, like the Child Abduction Convention or the Child Support Convention, which are very visible conventions with a huge practical impact. These conventions really are fundamentally designed to give real practical effect to basic principles that are enshrined in the UN Convention on the Rights of the Child, to which Kuwait, of course, is a party. But with these conventions and a series of these conventions, you would actually give yourself the means to give real effect to these fundamental principles established by the UN Convention. The second division is the transnational litigation and apostille division, with other conventions listed there. Today we'll focus on the apostille convention, and then we have this third division, which is the international commercial, digital and finance law or financial law division, with also two conventions and one soft law instrument that we are not going to cover today, but which might be of interest to Kuwait as well in the future. Here you see the evolution in terms of the number of contracting parties to our core conventions, our most important conventions. And I like to show this slide in today's context, because you see that the Apostille Convention has almost always been the convention with the highest number of contracting parties. It is a relatively old convention dating from 1961, but despite its age, this convention continues year after year to attract a regular high number of new contracting parties. We are currently at 124, and I can tell you in all confidence that later this week we will actually welcome the 125th contracting party to the Apostille Convention. So again, this continuing growth of the Apostille Convention shows that it remains absolutely relevant and of great practical importance despite its age. Now again, quick look at Kuwait and the HCCH. As mentioned, Kuwait is not a member yet, I'm tempted to add, but you have been connected, as we say, since 2002, so for more than 20 years. Kuwait has been a party to 4 HCCH instruments. That's 3 conventions: the Service Convention, the Evidence Convention, which both entered into force in 2002, and also a 1971 Recognition and Enforcement Convention, which is not one of our most visible or successful conventions, by no means, and there is no point in really putting a lot of efforts into this convention, also because it has actually been superseded by our newest instrument of 2019, the Judgments Convention, which is a new convention on the recognition and enforcement of foreign judgments in civil or commercial matters, a game changer, as I like to call it, which will actually enter into force later this year on the 1st of September. Definitely another convention that I would like to recommend to the authorities of Kuwait for further assessment. What I like to say about the work of the HCCH is that it really represents effective multilateralism. And that is illustrated amongst others by the fact that as we speak, the total number of ratifications and accessions or approvals of our conventions is 999. So as we speak, we have 999 ratifications, accessions, approvals, or other instances in which one of our conventions has been brought into effect or is about to be brought into effect in a contracting party. That in itself is an impressive figure, and again, with what I just said before, later this week, we will celebrate a real milestone in the history of the organization with the 1000th treaty action in relation to one of our conventions. But while this figure is, I think, impressive in and for itself, there is another way also to underscore its importance, and that is by asking yourself how many bilateral agreements it would take to establish the same number of treaty connections, treaty relations between states. So not using the multilateral approach that we pursue here at the HCCH, but if you had to go the bilateral way, you would need more than 31,000 bilateral agreements to establish the same network. And I think that shows again how effective multilateralism can be, in particular when you consider that it is also a very practical multilateralism with, again, a very direct impact on people's life or the way that commercial operators can organize their business. Now let's turn our attention to the main part of this seminar on the Apostille Convention. What is the Apostille Convention? Well, it's reflected also in its full title, the Convention of 1961, abolishing the requirement of legalization of foreign public documents. So what this convention actually does is it does away with the very lengthy, cumbersome process of legalization, and it replaces it with a much more effective, straightforward process with a single formality, that is the issuance of a certificate that we call an apostille. So an apostille is basically a certificate of origin of a public document. This apostille, or the apostille certificate, is issued by the state of origin of the public document, and it authenticates the origin, and only the origin, not the content of a public document, so that it can be presented abroad in another contracting party. And when we refer to public documents, we essentially mean documents like birth or marriage certificates, notarial acts, public school diplomas, patents, judgments, you know, typical public documents that are issued in one state and need to be produced in another one. And this Apostille Convention, through its simple formality, really facilitates the circulation of these public documents internationally, and again facilitates the lives of individuals, families, and indeed businesses. So the Apostille Convention produces the same effect as the legalization process, but it is the result of a much simpler, much more effective process. And that's illustrated by this little diagram here. This is the legalization process, therefore, so without the Apostille Convention. When you take a public document, say a birth certificate, you have to go to typically the civil register in the state of origin. From there, if you are lucky, you can go straight to the Ministry of Justice and then to the Ministry of Foreign Affairs. You would then still have to go to the embassy in the state of origin of the state of destination. So if a Kuwaiti document needs to be produced here in the Netherlands, you have to go to the Dutch embassy in Kuwait. If you are in a state of origin where there is no embassy of the state of destination, the process becomes even more complex and time-consuming and costly, because you have to go to the nearest embassy of the state of destination. So really a very cumbersome process, and very often in the state of destination, you would also have to go to the Ministry of Foreign Affairs before you can actually use the public document in the state of destination. So a very long, cumbersome, costly, very frustrating process, which frankly speaking is not of this day and age anymore. With the Apostille Convention, what you do is you take your birth certificate, you go to what is called the competent authority, which authenticates the origin of the document by issuing this Apostille certificate, and from there you can use your public document straight in the state of destination without any other formality. So much simpler, straightforward, faster, much more effective and efficient process. On top of that, the receiving person, the recipient in the state of origin, can easily assess the origin or check the origin of the apostille by asking the competent authority to check its register and see if the apostille has really been issued by the competent authority in the state of origin. The convention, as we speak, has 124 contracting parties. As I said, we're counting. The one that's going to join later this week is Canada. Please keep that for yourself. That's not an official news yet, but as you will see then with Canada, we'll basically have the whole of the Americas covered with the convention. It's also interesting to note the most recent accessions to the Apostille Convention coming from Pakistan, Senegal, and most recently China, that has also acceded to the convention for the mainland of China. The convention had been enforced for quite some time already in Macau and Hong Kong, but as of November later this year, it will also be applicable on the entire mainland of China, which of course is an important development. And there are other states in the pipeline, as we like to say, that are actively preparing accession. One of them is, for example, Thailand, but there are also others. Interesting also to have a quick look as to what the status is of the Apostille in the Gulf Cooperation Council. And you will see there that the convention has been in force already in Oman, Bahrain, and now also Saudi Arabia. But in Oman since 2012, in Bahrain since 2013, and a bit more recently in Saudi Arabia since 2022. I had the chance to visit the Secretariat and the Secretary General of the GCC when I was in Riyadh last year. And frankly speaking, it would make a lot of practical sense for all the GCC states to join the Apostille Convention and facilitate the circulation of public documents within the GCC region. By doing so, you would automatically also have the possibility to enjoy the easier circulation of these documents with the rest of the world, not just within the GCC, but indeed, as we have seen, with large parts of the globe. So I really hope that Kuwait will, in not too distant a future, be a contracting party to this convention and further strengthen the use of the Apostille Convention in your part of the world. Some key statistics which further emphasize the importance of the convention. So again, it is clearly the most popular of all our conventions, but it is by far also the most widely used. We don't have totally comprehensive data or statistics on the use of the convention, but based on the data that we have, we reckon that each and every year, somewhere between 30 and 35 million of apostilles are being issued. This probably means that the Apostille Convention is, one of the most, if not the most, applied international treaty in civil and commercial matters or legal cooperation there is. I don't know of any other convention that's being used that many times every single year. And with China now on board and others following, this number will, of course, only continue to increase. Another important element is that we had recently an expert office here in the Netherlands produce a study to estimate the economic benefit for contracting parties of this convention. And it is estimated that this benefit is more than €500 million every year for the contracting parties. And that benefit is mainly in form of time saved by the officials involved in the authentication process of public documents, but also the time saved by the users of the Apostille system. The World Bank Group essentially has come to the conclusion that a state party to the Apostille Convention is more attractive for foreign direct investment than a state that is not. In this report, Investing Across Borders, what the World Bank Group has done is assess how attractive states are based on, I can't remember, I think it was more than 80 or so criteria that they have taken into account. And one specific criteria is whether or not the state is a party to the Apostille Convention. And if a state is party to the Apostille Convention, the state gets, it's relatively speaking, actually more than a full point in this ranking of attractiveness for foreign direct investment. Similar message coming from the International Chamber of Commerce in Paris, which really urges all the states to become a party to the Apostille Convention and stresses the importance of it by saying that it is a global standard that is recognized and really expected to be enforced by parties involved in cross-border transactions. So all the more reasons for states to join this convention. As I said, it applies to public documents, which are basically documents executed by an authority or a person in its official capacity. So the contrary to documents that have been issued by persons in their private capacity. If you want a sort of a thumb rule as to which documents the convention applies, well, if you just remember the title of the convention, any document that was subject to legalization before the convention entered into force is now subject to apostille, because again, the apostille convention is designed to make things easier, practical, more straightforward, and so the more documents fall into the scope of the convention, the better is. And in case of doubt, we always say, just apply the convention because you don't do any harm in doing so, and you let people actually benefit from the advantages of the convention. It is the law of the state of origin which determines the public nature of a document. It is, however, the law of the state of destination which determines the probative value of the public document. So what is a public document is determined by the state of origin, but what its effects, including its value as evidence in the state of destination that is determined by the state of destination. Competent authorities, so these are the authorities that issue the apostille certificates. They have basically three responsibilities. The first and most important one is to verify the authenticity of a public document. So verify that the signature, the name, and the function in which the person has signed is correct. It issues and attaches these apostilles, and it then records the issued apostilles in a register that each competent authority has to operate. When I say competent authority, I should also say that it is up to each state to determine on its own which authority is a competent authority and how many competent authorities you actually may wish to have in your state. There are states with just one competent authority, typically the Ministry of Foreign Affairs. There are states with various competent authorities, distinguished amongst, depending on the nature of the underlying public document. So for example, birth certificates would go to the Ministry of Interior or maybe of Justice for being apostillized. And other documents may go to, for example, public school diplomas may go to the Ministry of Education for the issuance of an apostille. Other states have decentralized the system of competent authorities with offices around the state so as to be closer to the users of the system and to facilitate access to the system, which for large states, vast states, is a very practical element to take into account. So this is really what they do, these competent authorities. And in order for them to be able to actually do their job properly and authenticate the origin of a public document, they have to have access to a database or a repository of these sample signatures and seals and stamps that they are supposed to authenticate. So when you receive as a competent authority a public document with a signature and a stamp, you have to compare what's on the public document with what is in your database or your repository to be able to say with authority that yes, this is an authentic public document that really comes from where it's coming, where it says it's coming from, and it's not a fraudulent document. And of course, all of that process is made much easier nowadays if you use digital signatures, because of course that makes the whole verification process not only much faster and efficient, but also much more secure. This is the model apostille certificate as it is annexed to the convention. You see it's a very straightforward basic certificate with 10 standard items. The first relates to the public document itself, and the second part relates to the authority that has issued the apostille certificate. The convention is in English, and the apostille certificate is attached in English and French. Note that the title of the certificate has to be, or the reference to the convention always has to be in French. I don't know where this is coming from or why they decided this when they finalized the convention, but it's something to keep in mind. You have to have the reference to the convention in French at the top of the certificate. Then you have the 10 standard items. But you can have multilingual apostille certificates. That's allowed and actually encouraged under good practice of the convention. So you have here obviously the apostille certificate with Arabic used as language for the 10 standard items, with beneath the English and French translation. When it comes to filling in the apostille certificate, we strongly recommend and ask and require actually that these apostille certificates be filled in English and not, say in your case, in Arabic, because an apostille certificate is always meant for use abroad. And if you want to facilitate the use abroad and, you know, maximize your chances that the recipient understands what is filled in this apostille certificate, it is really good practice to fill this in English and make sure that the information is available in English. And that's what states do. So on that, I will now pass the floor to my colleague, Melissa Ford, who will talk to you about the electronic apostille program, which was essentially designed to make sure that the apostille can continue to operate in modern times with the use of technology that we are all become accustomed to. Melissa, over to you.
Thank you, Krestovf, and thank you for having me here today. So things have changed a lot since 1961, when the Apostille Convention was concluded. And as we sit here today, it's hard to imagine a world without technology, and without technology being used to conduct business transactions at faster speeds over multiple platforms with enhanced user-friendly interfaces. And in a world where information is now shared from one side of the world to the other in a matter of seconds, citizens and businesses engaged in transnational transactions expect to take advantage of these technologies to save themselves time and money. And governments are also focused on finding efficiencies and enhancing security through the use of technology. Governments, including Kuwait, are digitally transforming. And the Electronic Apostille Program, or the EAPP, as I'll refer to it from now on, forms part of this modern vision that strives to deliver efficient and secure transnational transactions for citizens and businesses. Launched in 2006, initially part of a pilot program back in 2012, it was then officially the EAPP. The EAPP supports the electronic issuance and verification of apostilles. And for governments where public documents are generally issued digitally, or they're intended to be issued digitally in the future as part of a digital transformation policy, the EAPP provides the most efficient and, if I may say, logical means to issue and verify apostilles. The EAPP continues to attract interest and uptake from countries across the globe. And on the next slide, I'll discuss the process. So if you'll recall Krestovf's earlier slide about the apostille process, you'll note that the workflow here is the same. It's just now electronic. All formalities required under the Convention remain the same for e-apostilles as they are for paper apostilles. This includes certifying the authenticity of the signature, the capacity in which the person signed the document has acted, and where appropriate, any seals and stamps used on the underlying public document. And the e-apostille must also be issued by a competent authority, which Krestovf referred to those earlier, from the state where the document emanates. And this must be attached, so the e-apostille must be attached to the underlying public document. Though with electronic documents, the method of attachment will obviously be different to attaching an electronic apostille to a paper document. We also must follow the model certificate annex to the Convention, which a previous slide had a picture of what that certificate looked like. And that certificate is also used for the e-apostille. Once an e-apostille is issued, it can be presented directly to the authority in the other contracting party. Validly issued e-apostilles must be accepted by all other contracting parties, just the same as paper apostilles. And the beauty with the EAPP program is that recipients can quickly verify an e-apostille through the e-register. And so this slide that we're on at the moment, which I'd like to stay on, is a little bit more about the e-apostille. And so just quickly to recap, the EAPP has two components, the e-apostille and the e-register. So I'll stay on this slide and just talk about the e-apostille. It is a certificate that is issued pursuant to Article 3(1) of the Convention, and it's issued in electronic form with a digital signature. I mentioned before that it was an excellent tool to use where public documents are already being issued digitally. There are a number of benefits to using e-apostilles. It will reduce the workload for competent authorities by removing the need to physically attach, sign and seal paper apostilles. It reduces turnaround costs and time in the issuance of the apostille, and so it can provide more cheaper and effective methods for using the apostille convention. It also can increase security by using technology to ensure the document has not been tampered with from the time that it has been issued to the time that the apostille has been issued. We'll now see an example of an e-apostille on the next slide. And so you can see here, we use the standard 10-item certificate. There can be some text outside of the box of that certificate there at the bottom to highlight that it is an electronic apostille and that it has a digital certificate, a digital signature. And that digital signature, the e-apostille, is attached digitally to the underlying public document. We'll see there might be another example of an e-apostille on the following slide. Actually, this is an example of the e-register, which I'll now talk to. This is an Article 7(1) register that is maintained in electronic form, and it's publicly accessible online. It can be used to record the issuance of both paper and electronic apostilles, but the publicly accessible element is what makes the e-register a component of the EAPP program, so the EAPP rather. So it's when an e-apostille is presented to a receiving agency, they can look at the QR code and they can check back instantly to the e-register and search online to confirm that the e-apostille has been validly issued. But it only allows an interested person to verify their apostille online. So it's not available to the world to search up individual apostilles. So only the recipient has the information to access and use the e-register to verify apostilles. In some cases, QR codes are used rather than a public URL, and you'll see there is an image there of a QR code. And I think I have an example of an e-register as well, yes, on the next slide. And here you can see the QR code on the e-apostille that will take the user back to the e-register for verification. Having this component of the EAPP really facilitates the operation of the Apostille Convention, as it provides a rapid way to check that an apostille, be it paper or electronic, has been validly issued. You can also see some verification codes and certificate numbers there that are used in the verification process. So next we'll look at where the EAPP has been implemented. If we can just go back one slide for the implementation. We'll just quickly have a look here. As you can see from this slide, EAPP implementation is starting to grow, with 30 countries having the e-register and the e-apostille, and a total of 51 countries having implemented the e-register only. I can say that, and as Krestovf has mentioned as well, we have a number of contracting parties that are looking to upgrade to the EAPP. So I do expect this number to grow across the globe, and this EAPP component of our work keeps us very busy. While the Permanent Bureau oversees the EAPP, the development and implementation of the components remain the responsibility of contracting parties. And so we don't prescribe specific technology for contracting parties. This is at their discretion to choose how they wish to implement both components of the EAPP. We also facilitate an international forum, which is held every couple of years. And this is designed to bring people together to discuss the EAPP and to share experiences. And as we get more contracting parties implementing one or both components of the EAPP, we've really developed a great repository of knowledge of technology that can be used and problems that can be solved between contracting parties. And so the Permanent Bureau is happy to connect contracting parties to share experiences in EAPP implementation. And finally, I just wanted to mention the handbook. We have in January 2023 launched the second edition of our Apostille handbook. This is a very user-friendly, practical guide. Now in its second edition, the first edition was translated into a number of languages. The second edition is available currently in English, French, and Spanish. We obviously would welcome an Arabic translation, and so would be very open to be contacted if there was an offer to translate this handbook into Arabic. It's a very useful tool, and it's certainly the tool that a lot of our contracting parties use on a regular basis. And so we also have the website, which provides a lot of other information about the Apostille and the EAPP. So that concludes my component of the session, and I'll hand you back to Krestovf. Thank you.
Thank you very much, Melissa. And just to add that the handbook is accessible for free on our website in English, if in the meantime you want to have a look at it. So just coming back then to the benefits for Kuwait, I think they are pretty straightforward. You will have understood that using the Apostille Convention really means facilitating the circulation of public documents, increasing accessibility for users through this standard process, which is expected to be in force and which is recognized by all contracting parties. A very important benefit is that you free up resources in the consulates. I hear that again and again from officials who used to be involved in the legalization of public documents working at consulate offices, and now they have more time to do more important things than just stamping and signing public documents. Another important benefit for states. In all transparency, I always also like to remind states that by joining the Apostille Convention and therefore abolishing the legalization procedure in relation to all the other contracting parties, you obviously also lose the revenue generated through the legalization process thus far. But I immediately add that with the Apostille Convention, you actually open up a new source of revenue, because nowhere in the convention is it said that apostille certificates should be issued for free. I think there are only a handful of states that continue to issue them for free. All other contracting parties do charge a fee for the issuance of an apostille. And some studies done in a few contracting parties have shown that the states very, very quickly balance out the fact that they lose the legalization revenue through the revenue that they now generate through the apostille. And because the apostille system is so popular and widely used, very quickly the apostille revenue actually is higher than the revenue generated through legalization initially. I have referred to the situation in the GCC. Again, by using technological developments, you can really ensure that the Apostille Convention will continue to be relevant for decades to come. I am convinced that technology will not replace the apostille system as such, because people take a lot of confidence to know, by knowing that a state designated authority has been involved in the issuance of an apostille, including an electronic apostille. So you will never only rely just on technology, but you will always want to have this state involvement in the process. That gives the additional assurance and comfort to the users of the system. It does facilitate international trade, commerce, and foreign direct investment, as we have seen. And again, one cannot overestimate the practical impact that this has on people's life, and how frustrating it is for people when they know that there is an apostille system available, but it's not in force in a given state. I have had the experience myself with our children born in Canada, where the Apostille Convention is not in force until a bit later this year. But to go through the legalization process is just a nightmare. So I wholeheartedly invite Kuwait to join and become part of this international standard. I think it would really make things much, much easier and more efficient for thousands of users. How to go about this? What is the process to join the Apostille Convention? At the international level, Kuwait can accede to the convention. You cannot ratify the convention at the international level, because ratification was only open to all states that were represented at the diplomatic session back then that finalized the text of and adopted the convention. So all states nowadays accede to the Apostille Convention, and the process is essentially in 3 steps. You have a contracting party that deposits the instrument of accession with the depository, which is the Ministry of Foreign Affairs of the Netherlands here in The Hague. And in doing so, you also would designate the competent authority or the competent authorities that you have designated as issuing these apostille certificates. With that deposit of the instrument of accession starts a 6-month period during which the existing contracting parties have the opportunity to object if they want to do so. That happens from time to time, but it's really absolutely the exception, certainly given the number of contracting parties we have. But after these 6 months, you have an additional 60 days before then the convention does actually enter into force between the acceding state and all the other contracting parties that have not objected. That is the vast majority of the contracting parties. That's what we really wanted to share with you by way of introduction of the HCCH in general, to give you some background, the Apostille in general, so that you are familiar with the system of the Apostille, but also sharing with you what is currently happening in a number of contracting parties in terms of using technology and making the Apostille system even more effective and secure through this EAPP, as explained by Melissa. And with that, Dr. Bashayr, I hand the floor back to you, and we'll be happy to take any questions you may have after your presentation. Thank you.
Thank you very much. Good afternoon, everyone. I would like to thank the Dean of College of Law, Dr. Abdurrahman Al-Radwan, and the Head of International Law Department, Dr. Abdussalam Al-Anizi, for their encourage and support to organize such a presentation today. And a big thank for our colleague in the IT department for their help. Dr. Krestovf and Melissa, thank you very much for giving us such an insightful presentation and sharing with us your experience and the main technical information, because reading the convention and the handbook is not easy. So you try to bring the main points to our attention. Before I begin my presentation, I would like to acknowledge that some of points may already been covered by Dr. Krestovf and Melissa. So I will try to provide explanation for the current position in Kuwait to enforce and use foreign public documents, and what is the situation or main question for authorities to become a member to this Hague Apostille Convention. Obviously, Kuwait is not a member of the Hague Conference of a Private International Law and is not a member to the Hague Apostille Convention. The main question is what the current process to present foreign public documents like birth certificate, notary documents, power attorney, and other certificates to be used in Kuwait. Essentially, there are two ways in Kuwait to present a foreign public document. The first is through authentication, and the second process by obtaining an order from the court to execute such document. I will explain both ways briefly. In relation to the first process, which is authentication, usually described as the diplomatic way, because we need the embassies consular to authentic such documents abroad where the embassy of the country located. And then these documents need to be authentic in or by the Ministry of Affairs, because it's the Ministry of Foreign Affairs is the responsible for such a process. The second alternative way, which is unusual, is the judicial way. Because here in Kuwait, following the rules set out in Articles 201 and 202 of the Civil and Commercial Procedural Law, provide certain conditions to enforce foreign public documents in the country, which is required from the interested party to submit an application to the director of the execution department, and must satisfy the reciprocity condition. Bear in mind that Kuwaiti courts will avoid enforce any document violates public policy. So if the foreign public document failed to satisfy some or all of such conditions, then the Kuwaiti court will refuse to execute such a document in the country. It is interesting to know that if Kuwait become party to the Hague Apostille Convention, then such a procedure set out in the judicial route or the diplomatic route would not be necessary to follow, because as mentioned by previous speakers, this convention will help to ease the formalities in use a foreign document in a contracting country. But the main question is, if Kuwait become a member to the Hague Apostille Convention, what are the required procedures to be implemented in Kuwait to enforce such a convention? We have to look at Article 70 of the Kuwaiti constitutional law, which set out the main procedure to enforce a treaty in the country, because any treaty is not self-executing, which require the Kuwaiti parliament to agree the treaty as a first step, and then publish the treaty in the Kuwait official gazette in order to become enforceable in the country. When I read the convention, I start to think about something practical, because what I try to see in practice, that sometimes I have to authentic some papers in Kuwait Ministry of Justice and other documents in the Ministry of Foreign Affairs. So I try to think that if Kuwait become a member to the Apostille Convention, is it necessary to appoint a single authority, as mentioned by Dr. Krestovf, that some countries appoint a centralized authority? So there is an option, it's optional according to Article 6 to appoint a single authority or a multiple authorities. And if Kuwait choose to appoint different authorities for different type of document, this is possible because here we can use apostille for marriage and divorce documents in the Ministry of Justice, and other documents like business certificate, birth certificate in the Ministry of Foreign Affairs. And it is more practical if we can use Ministry of Education to issue apostille for academic certificates. So this is an optional and more practical that the convention covered in Article 6. Actually, when I tried to talk about this convention with my colleagues, actually the main question is, how can we avoid fake foreign apostille documents? So here, it is important because the convention itself doesn't deal with this issue directly to provide criminal steps to be taken by an authority. But here we can use the facility of the convention by rejecting documents. So, for example, if Kuwait become a party and it's a receiver authority, they have to the option to reject such a document, and they have the option to contact the competent authority in the original country to check whether the particulars stated in the apostille certificate is correct or not, and whether it's correspondent to those recorded in their register or not. So this is a practical step that can be taken by the contracting state. I'm happy that Melissa shared the main points of the apostille program, because when we look at the convention, it's agreed in 1961. So it is important to incorporate technologies development in this area. Actually, I couldn't understand whether, and this is one of the questions that I want to raise for the speakers, that I'm not sure if the EU program is an optional or it's a compulsory, that a country, when it becomes a member, they have to choose the paper form as well as the e-form apostille, or it's an optional to choose either way. So this is one of the questions that I would like this other presentation or my colleagues to answer it, because it would be helpful to clarify it for our audience. Here, I will come to the end of the presentation after I explain the current situation of Kuwait, and I encourage my country to become a member, because it would ease the circulate of documents globally, and will help to bring Kuwait to share global countries and businesses by using global documents. Here, I would like even to thank Dr. Krestov's when he mentioned that there is a regional offices, and it will be a plan to have different locations around the world, and one of the plans to have in MENA. And actually, I encourage that one of the offices located in Kuwait, because Kuwait is a business hub and will be one of the big collaboration between The Hague and Kuwait in the future. And I'm looking forward that my government will take this step, and I encourage it. Thank you for your presentation. And if you can provide us with the answer for my question, I appreciate it.
Thank you very much indeed, Dr. Bashayr, for your very informative explanations as to how things are done in Kuwait currently, and indeed also for your support towards Kuwait's joining of the Apostille Convention. I was very interested in learning that you have two systems currently in place, the diplomatic way and the judicial way. And I think in this context, two things are important. One is that if and when Kuwait joins the Apostille Convention, that becomes the maximum formality that can be required for the authentication of foreign public documents. Once you have joined the Apostille Convention, you can no longer, in relation to other contracting parties, require any formality that would go beyond the simple issuance of an apostille. However, that's the second point, what I refer to as the probative effect remains absolutely subject to the law of Kuwait. So if you have a foreign public document that has an apostille, a valid apostille, but the underlying public document has content that violates your public policy, you are under no obligation whatsoever to recognize the content of the public document, because an apostille has nothing to do with the content of a public document. It's only about the origin. So all the apostille does is to tell you that, yes, this apostille really comes from the competent authority, say here in the Netherlands, but if it has, or it is attached to a public document that violates public policy, or that otherwise you can determine by way of rules of evidence that the content is wrong, the content of that public document will have no effect in Kuwait. Again, I cannot stress this enough. It's not because you would join the Apostille Convention that suddenly the status of public documents in Kuwait would change. The Apostille Convention is only here to facilitate and simplify the process of authenticating a public document. That's all there is to it. Thank you for your reference to what I think was Article 70 of your Constitution. And there are, of course, yes, absolutely, your internal processes that you have to go through, including publication in the Gazette and all of that. And I don't know if it's an executive order or if you need to involve an assembly or the assembly, parliamentary assembly, to have the process completed. But whatever needs to be done at the internal level needs to be done before you can deposit your instrument of accession at the international level with the depository here in The Hague. And then, as I explained, the process follows. As you absolutely rightly recalled, it will be for Kuwait to determine what is the best system in terms of the competent authorities. Do you want to have one or more competent authorities? I personally, but this is just me personally speaking, I have a lot of sympathy for a system where a public document is brought to a competent authority that is the most accustomed to these documents, and so that, for example, educational documents would be brought to the Ministry of Education, which I take it has a repository of all the signatures that are used in universities or public schools, that to me makes a lot of sense, and I have a lot of sympathy for that, and that's a system that's being used in various states. But again, the basic rule is to make these things as practical as possible. And to ensure a proximity of the system for the user. Now, traveling to Kuwait City is probably not asking too much from people, because I'm looking at Melissa in Australia, the distances are far bigger. But here in the Netherlands, for example, there are how many 20-something competent authorities, I think. So in each region. It's the higher court actually that is the competent authority. So that's a judicial competent authority. But in most other contracting parties, it's typically the Ministry of Foreign Affairs, maybe the Ministry of Foreign Affairs and Ministry of Justice, or various Ministry of Justice. But there are also systems where you have one single competent authority, which, however, has various offices in the regions. So you would still designate just one competent authority, but to ensure proximity, this single competent authority has offices around the country that people can go to and ask for the apostille. But again, the beauty there is that the convention provides you with all the flexibility that you may wish for and require.
Actually, Dr. Christopher, you provide us with a good explanation, and I'm happy that Kuwait share an interest to understand this convention, and I hope in the future that to see Kuwait a member and implement such rules. And become more easy to use such documents within Kuwait or abroad with ease, and this is our desire. I think we need to come to the end for this presentation because the time for Zoom, we come to the end. Thank you all for your time and attention. And I would like to thank you for your accepting to provide us with such information. And thank you, Melissa.
Thank you also on our side, Dr. Bashir. And I think what I would like to add simply is, other than renewing our thanks for your interest, to let you know that we remain at your full disposal for any further information that you may require. We have contacts here with the Embassy of Kuwait in The Hague, but I think it might be important at some stage also to enter into contact with the authorities in Kuwait themselves, so that we can hopefully continue this dialogue and encouraging the relevant authorities to make sure that Kuwait can join this convention, which brings a lot of positive elements and benefits to the users. So thank you from our side. Just a final comment on the regional office that you kindly picked up on. Regional offices can only be established in members of the HCCH. So if you want to have a regional office in Kuwait, the way to go is to become a member first of the HCCH, and then I'm happy to discuss matters further. But thank you very much for your interest and for your time. I appreciate it. And thank you, Melissa.
Thank you very much.
Thank you.
Thank you.
And our IT department also. Yeah. Thank you.
Yeah.
Thank you.
We hope we can see you very soon. Thank you. Bye.